the city responded to our motion not on the substance of the matter. They adopted a kind of a procedural posture where they said that the advocates don't have a right to vindicate this constitutional right to know because they don't have an interest in the lawsuit. And it's our position that the right to know belongs to the public. So any member of the public has an interest in the lawsuit to the extent that the lawsuit violates the right to know. But yes, we responded to the city pointing out that, in fact, the court has never entered an order that required the parties to submit information in the case under seal. And, I can demonstrate this by pointing to an order that the court entered into the record on December 1st, 2014. That order was in response to a motion by the city to hold the defendants in contempt for disclosing valuation information about Mountain Water Company. And, that's just not what the court ordered. And the court said that this, quote, this litigation is an important public issue and one that involves governmental entities, and the court does not find it necessary or appropriate to order a bright-line rule regarding what parties may or may not say, unquote. And so she denied that motion that the city filed to keep the matter secret. And since that time, the representations by the city that there has been some sort of order sealing this information is just not an accurate reflection of the record. And so we try to point that up in our reply brief, as well as the fact that the city doesn't invoke any law or legal authority to keep the matter sealed. Rather, it comes after the advocates on procedural issues, but not substantive ones. And ultimately, if it wasn't for the city's refusal to consent to our motion to release this public information, we wouldn't have had to file a brief, and there wouldn't be this, the city wouldn't have had to file a brief, and we wouldn't have had to file a brief. And I think that because the city has taken this position that this information should be kept secret, that not only should our motion be granted, but the city should have to pay the attorney fees of bringing the darn thing.
So what happens next? Is it in the judge's hands now?
It's in Judge Townsend's hands now, and no one has requested a hearing in open court on the matter. If she wants one, she'll set one. But other than that, it's ready for her to rule upon.
All right. Now, do you anticipate, due to past decisions that she has made regarding this mountain water matter, do you have any idea which direction this might go?
Well, I think based on her order of December 1st, 2014, a copy of which we've attached to our brief, that if she's consistent with that, she'll grant the motion, and if not grant the motion itself, at least order that the information be made public. The public has a right to know, and there's just no two ways about that.